This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
In this matter, I'll bring by Mr.
But I am for the petitioner.
Yes. Who
But
is your
this-
other side?
My lord, I
Service.
appear lordship for the state. I appear
My lord,
lordship.
kindly see, my lord, no proceedings could have been initiated as per the Supreme Court judgment. I will just place that. Kindly turn to, my lord, page 35. This was the Rule 239 application. Permission was granted in 23, sorry. On 10th of April 2023, was granted. Then the renewal application was made. And on the renewal application, the internal file movement was going on. Kindly come to page 36. Madam will notice that the licensed premises are not concerned others. Glenary's RCB, which is one of the 150 years heritage organization running in Darjeeling. Then a report was sought for. Finally, my lord, nothing was done. Nothing was communicated to us. Now I am penalized for this. Kindly come to the impugned order. And I will cite one Supreme Court judgment where Supreme Court in similar case says you cannot do this since the application was there. The impugned order starts at page 43. My lord will kindly come to the page 44 middle portion, which is the main concern. The conduct demonstrated that deliberate, intentional and persistent non-compliance, indicating that the licensee is willfully and consciously involved in conducting such unauthorized live band, musical performance, despite being fully aware of the relevant excise rules and the ongoing miscase proceedings. The licensee also admitted that no fresh application seeking approval for live band music for so-and-so had been submitted to the collector. This is absolutely wrong recording because the document shows I have placed before your lordship documents that my application was there and internal communications were being made asking the detail of the situation. Now, penalty is imposed in such a case, 90 days suspension. Now, under the law, I take the words, they have the three options, either to cancel, suspend, or to impose monetary penalty. The authorities did not at all consider which is necessary for this imposition. But my first submission, they cannot proceed. Kindly takes up the year 1991 Supreme Court.
No, first of all, please show me that your application seeking approval for live band
Yes,
music.
that
Where
was
is that?
first. Kindly come to page 35. This was the license granted in 2023. Permission under Rule 239.
And it is valid for how many
Valid for
days?
1 year.
23 to 24.
And my application in 24 was filed. That was under consideration. Kindly come to page 36.
31st of March 24, page 35, this was valid. Granted
Yes.
permission under Rule 239. Is Rule
239.
239 relating to the
The
live
performance-
band?
Yes, live band and musical performance.
Music and singing shall be for no case there shall be more than two performers on the stage. Nothing other than music and singing will be performed.
This Rule 239 is not applicable for Calcutta or metros, but this was other areas. Anyway, I accept that. Then kindly come to page 36.
Yes, 36.
36 will find that the Superintendent of Excise was writing to the Superintendent of Police Darjeeling, subject issuance of no objection certificate for granting permission under Rule 239. This is on 11th July 2024.
Yes.
Therefore, my application for renewal was before them, which is they were considering. Now,
Yes.
ultimately, again, kindly come to next. Sorry, the next page speaks of June communication, and this July is 36. Therefore, admittedly, my license application was under consideration.
All right.
Yes. Now, in this background, whether they can proceed against me, I am relying upon the Supreme Court judgment. The year 1991 Supreme Court, page 515, my junior will give you the corresponding one. In identical situation, Supreme Court said you cannot do this.
Yes.
515, corresponding page, I am not sure whether he has given IIR or
This is more SSC. SCC
SS.
has been given.
Yes,
Murali
correct.
Lal. Murali
Yes,
Lal.
yes, yes,
Jhunjhunwala.
yes, yes, yes.
Yeah. Which portion you want to rely?
Milord, kindly come to Milord paragraph 4. The paragraph begins, the authority, however, prosecuted the appellant. Got it?
Yes.
Appellant for carrying on business without license. It appears the collector of Giridih, who is the licensing authority under the license unification order, directed the district supply officer to prosecute the appellant for violation of section 10 of the Essential Commodities Act. The question is whether there is any justification for prosecuting the appellant. Technically, the authorities may be justified in prosecuting the appellant for carrying on business without obtaining the license. But the facts of the case reveal that the appellant is not to be blamed. If there is anybody to be blamed in this case, only the licensing authority who has failed to perform its statutory duties. The appellant has done all that he could do under the law. He has not been told at any time that he is required to do anything more than what he has already done. For successive 4 years, the licensing authority went on accepting the application for license with necessary license fees, and no time it denied the claim of the appellant. Its silence seems to demonstrate the total lack of awareness of the rights of the appellant. To cover up its own inaction and lethargic attitude, it seems to have directed the prosecution of the appellant. The attitude of the licensing authority is beyond our comprehension, not compensation. It is arbitrary on the fact of it and unjustified on every aspect of it. We fail to understand why the appellant should be prosecuted when he, on his part, has done everything for obtaining the license. The appellant was legitimately entitled to license which has been unreasonably withheld for him. It would be indeed wrong on the part of the licensing authority to prosecute the appellant. In the circumstances, we allow the appeal, set aside the order of the High Court, and quash the proceedings against the appellant pending in court. Now, therefore, they don't have any authority to proceed against me, number one. Number two, even if all credit is given to them that they have the authority, the question would come proportionality of the penalty. If you say that this is in violation of 239, though the application was pending, you cannot suspend me for 90 days. That too particularly such a time when he is the best earning period for a businessman.
Give me 239 once.
239 kindly takes up, Milord. That is again I say page 35.
Page 35, I have the permission, but I want to see the rule.
Rule. Yes,
No.
rule ta proceed karo. 239
West Bengal excise rules. Is it here?
Not I have.
है तो कॉपी दो डॉक्टर साहब के.
Oh, thank you so much. The book is here. Yes, I have a copy.
Yes. That this is permission required except for Calcutta.
Let me I read. No license detail.
আস্তে আস্তে শোন.
বলো না ওরা বলতে হচ্ছে মামলা হচ্ছে বলো.
All right, I have seen it.
But therefore, Milord, I would pray, Milord, kindly stay this. Even if ultimately I fail, Milord, the suspension of 90 days, then thereafter it may be affected. But every chance, Milord, I will succeed.
All right, let me hear.
My lord, may I tell Lordship? My lord, if your Lordship kindly have a look. My lord, it's a first of all, it's a reason order. Everything my lord stated herein. If your Lordship kindly have a look first. My lord, the order itself. My lord, the order is at page number 39. Have your Lordship got it, my lord?
Yes.
Page number 39. Now, my lord, kindly have a look. This is a matter, my lord, where all natural justice followed, my lord, the provisions of the statute followed, and the authority who has passed the order, he have had authority. Now, Lordship, kindly come, my lord. You are hereby, this is, my lord, 39 was the show cause notice. Now, my lord, 39 show cause. Now, order of irregularities. Non-maintenance of regular accounts. This is not only 239. Non-maintenance of regular accounts, attestation of accounts by licensee. Then Rule 231 mentioned herein. Then holding performance, entertainment, dance, live band without written permission under Rule 239. Not only Rule 239. Then storage of foreign liquor as an unauthorized premises in violation of license condition and Section 16 of Bengal Excise Act 1909. Then added also other irregularities mentioned below. I am not on this, my lord. There are several irregularities. Now, my learned page says that it has been terminated only on, my lord, violation of Rule 239. My lord, worship kindly, and it is submitted. Whole submission is that application has been made for the year 25-26, that is the current year, and it has been pending. And during pendency, my lord, we have terminated, my lord, or suspended. Now, my lord, kindly have a look. My lord, the reply to so cause. It is an, my lord, fully, my lord, admitted case. Lordship, kindly have a look. Page number 41. Page number 41, Lordship, kindly have a look. Page number 41, it is, my lord, answer to so cause. That is, my 11/11/2025. Regarding music at Glenary's bar, you are correct that we have music playing at our restaurant. We had applied, not we have, we had applied for
Yes.
permission last year as required, and the approval was typed and signed by Superintendent of Darjeeling Police. Maybe whether it is not in our excise department. Unfortunately, for reasons beyond our understanding, signed permission did not reach your office. Very good. We have a copy of the approval. Let us, my lord, pause here for a moment. Suppose that 2024-2025, a license expired, but validity is from April to March. The next, my lord, that is, my lord, the March, April to March. Had it been also, let us, for the sake of argument, my lord, it was approved, suppose. Deemed approval. Then if it is a deemed approval, its validity period would have ended, my lord, by, my lord, 31st March of 2025. Then he has to apply afresh for the current year. The violation that has been noticed, not for last year, this year, current year. Now, my lord, the next paragraph. Next paragraph. We have applied again for the current year. This is totally untrue. My lord, I do not want to say false. Totally untrue. Not a single, my lord, the paper supporting to this that they have applied this year also. This is not correct. Then, my lord, kindly see, we are hopeful of a positive outcome. So, on the basis of their hope that there would be granted, so they say they take it granted. So, they, my lord, continued this violation of Rule 239. Now, apart from that, if your lordship kindly have a look, my lord, that the so far the others, my lord, that is, my lord, non-maintenance of accounts book, my lord, there is also, my lord, an admission that yes, my lord, there is an admission also. Now, under these circumstances, now if your lordship kindly have a look, page number 41, page number 41, lordship kindly see. Another admission and or acknowledgement, page number 41. Once more, lordship. My lord, it is serial number or clause number 2. Concerning bookkeeping discrepancy, we acknowledge that an error occurred in the issue and receipt records, mainly because multiple staff members handled them during the main bookkeeping. This is not an explanation. We can say this is excuse. And even if it is explanation, lordship, my lord, it should be to the satisfaction of the authority concerned. Now, everything now, my lord, under these circumstances, when it's a totally, my lord, reason order, first of all, my lord, there was an inquiry. Now, my lord, kindly consider one thing. My lord, inspection book normally and all the time is being kept by the licensee. Now, my lord, after the inspection is over, my lord, the inspectors of the inspection team, they made their, my lord, the opinion on the inspection book, and it is being kept by the licensee. Now, my lord, the inspectors, they just, my lord, took out the copy thereof, and it is being, my lord, in the file of the excise department. But the original book, the inspection book, is with them. Now, my lord, it is not a case, the inspection that was not, my lord, handed over to them, the report. So, cause, reply, hearing, show, and reason order, and communication. So it is a case, it is not a case of violation of natural justice. It is not a case of that no, I have no power. Power emanates there.
Mr.
Violation.
Sen,
Now, my lord, the provision of
Mr.
the, my lord,
Sen,
the rule 8.2. My lord,
1 minute, Mr. Sen.
applicable order. My lord's own order. My lord's own order on earlier occasion. Lordship, kindly for another
1
2
minute,
minutes.
Mr. Sen. If there are certain irregularities that have been found,
My lord.
let the petitioner cure the irregularities at the earliest.
Yes.
All right.
My lord, may I tell?
I am
My lord,
posting
there
the
are
matter
two
next
aspects.
week. In
Two
the
aspects.
meantime,
Two aspects. Lordship, kindly consider one thing. Two aspects. One thing is irregularities that can be cured. There is no, my lord, the question that all. That it cannot be cured. Regarding bookkeeping and other thing, irregularity, something else. But so far the violation of the rules, the
Yeah.
offense, how can it be cured?
all right,
Which had
offense,
already
we will
happened.
see.
What
We
that
will see.
consequence
Today is
followed.
Wednesday. Let everything be cured by this week. Monday, I am posting the matter. Let us see. Let your officers go and see whether the irregularities have
Yes.
been
May
cured
I
or
tell?
not.
My
And
lord,
thereafter, Monday, we can
may I
pass
tell?
necessary
Bookkeeping,
orders.
my lord, I have followed what fell from your lordship. My lord, the bookkeeping can be regularized. Or my lord, the storage, unlawfully or irregularly storage, that can be regularized. But my lord, so far the offense already done, committed. May I tell? My lord, the smile cannot be, but the question is, my lord, চলে গেল কেন? My lord, my lord, the question is that it's an appellable order. My lord, rule
Yes, it's all right.
section
Let
8,
the
subsection 2. And my
let
lord,
the
section 8, subsection 2, it's an appellable order. My lord knows it very well. Then when the order is from my lord, the collector,
you will
there is
be
the
more
affidavit.
interested in curing whatever defects that are there than relegating the petitioner to some other forum, right? Let them cure the defects. Whatever is curable as regards the offenses, we can see what can be done. I am
Yes.
posting it on Monday, and
My lord,
let the defects in the
tell? My
meantime be
lord, let
cured.
them cure. We cannot stand in the way to regularize their own, the bookkeeping or other thing. But the thing is this, my lord, what happened already. There, my lord, with regard to, my lord, that the unauthorized or, my lord, the construction without knowing us, my lord, without, my lord, placing the layoff plan, they have, my lord, done many things. And all these things are, my lord, mentioned in the reason order.
Well, what he's
In the
saying
reason order.
is
So
continuing
curing,
for
my
more
lord,
than
let them
150
cure.
years.
Let them cure. My lord, that is not
This is
the fact.
nothing new. I think
But
Mr.
the,
Sen's
but
client has
the,
not given
but
Where
proper
is the
information.
latest
question is, then, my
application
lord,
for the year
everyone say
2025-26? Where is that
no,
application?
no application has yet been made.
239
25,
application. Where
26,
is the application
no
for the
application.
current
Let
year?
me
The
show there is an application.
239, Milord, since Milord, the 2004 application was not finally known to
24
us by
application was
then.
not considered. You did not file the application also. Please come.
Yes.
The order dated for 2nd/4th December 2025. Passed by the ADM within bracket G and Collector of Excise. Darjeeling is impugned herein.
My contention, it is an appellable order, my lord, lordship. My lord,
Stop.
own
Next.
order.
The
My lord, on earlier
matter
occasion
relates
refused to
to
entertain on
the
similar circumstances.
non-compliance of Rule 239 of the West Bengal Excise within bracket foreign liquor bracket close rules, 1998 as amended at the licensed premises of Glenaries.
And there are other violations also, lordship.
Stop. Apart from the above, it appears there are certain other violations. Stop. The petitioner was heard and the petitioner has been And the license of the Glenarys restaurant cum bar has been directed to be suspended for a period of 90 days from the date of receipt of the order. Stop paragraph. The petitioner is aggrieved by the same. Stop. It has been submitted that the restaurant is in operation for more than 150 years. Stop. The reply to the show cause annexed to the writ petition admits of certain irregularities. Stop. Next. According to the state, the order is an appealable one, and the petitioner ought to approach the appellate forum. Stop. The petitioner contends that the license ought not to be suspended, as the application for grant of license under
Rule 239.
Rule 239 of the rules for the year, for the previous year, was not disposed of, and the same remained pending. Stop. Next. There is nothing on record to suggest that application for the current financial year under the said rule was made by the petitioner. Stop paragraph. As quite a few of the irregularities pointed out appears to be curable, hearing of the writ petition stands adjourned till 22nd December 2025. Stop. In the meantime, the defects that can be cured shall be rectified. Stop. It will be open for the authorities to visit the restaurant cum bar premises for inspection. Stop. Inspection report shall be placed before this court on the 22nd December 2025, when the matter will appear in the list once again.
Deeply obliged.
Good.
But the proportionality of punishment will also be considered.
I'll take care on the next date.
Yes, deeply obliged.
Take my cues.